Good afternoon, ladies and gentlemen. We have started a series in going through the Constitution of the Cooperative Republic of Guyana. Last week, my colleague began by looking at parliamentary privileges, which is a very vital and important topic for us to consider before we go on to today's discussion. Today, we want to move the discussion a bit further, and we want to examine the separations of power. You will not be able to understand fully if you do not first contemplate and understand that we should be considering three main pillars whenever we're talking about the Constitution, and whenever we're talking about separations of power. We should be considering three pillars. Those three pillars are the legislative, the executive, and the judicial pillar. Some persons will consider it as branches of the state. But I want to begin this by firstly looking at what Justice Saunders mentioned, or what he reasoned in the case of Benjamin and the Minister of Information, which is a 1997 case. This is what Justice Saunders, President of the Caribbean Court of Justice, said. He said, whenever we're considering separations of power, and I quote, "Our democracy rests on three fundamental pillars: the legislative, the executive, and judicial. All must keep within the bounds of the Constitution. The judicial has the task of seeing that the legislative and the executive action does not stray outside those boundaries onto forbidden territories. If that occurs, and a citizen withstanding complains, the court declares the trespass and grant appropriate remedies." Further, Justice Saunders reiterated that there is a fine line which the courts must tread in circumstances whenever we're talking about the separations of power. On one hand, it must protect the citizens and guarantee them the rights and freedoms which the Constitution proclaims. On the other hand, the courts should not intrude into the or the preservation of the branches of the state. What a key way to begin this conversation. A key way to begin this conversation is simply understanding that our democracy, and the democracy of the entire Commonwealth Caribbean, rests on three pillars working together, but yet still separate. There must never be a crossing of the roles or functions of either of these branch or pillars, that being the legislative, the executive, and the judicial arm. Because to cross paths and to operate in the function of the other will definitely cripple the smooth running and operations of our democracy. For our democracy to operate effectively, it has been said that it is necessary that a certain relationship or comity should exist between these three branches. Now, each branch must respect the role and function of the other. The court is subject to and must enforce laws which are passed by Parliament. And those laws which are passed by Parliament, the courts are obligated to enforce those laws once the laws are in keeping with what the Constitution mandates. If there is any law which falls outside of the Constitution, then the courts will have no right to enforce that law. I have said repeatedly that the courts are considered, not only in Guyana, but in the Commonwealth Caribbean, the courts are considered, very importantly, as the guardian of the Constitution. Therefore, a court has no right to enforce a law which is outside of the Constitution. Now, the executive should respect and obey the decisions and accept the inclinations and the directions of the court. The executive receiving an order of the court cannot determine or should not determine that they will not carry out the instructions of the court. If that were to happen, then again, we are looking at a disregard, or we're looking at a practice which creates a dysfunctional democracy. Now, the relationship must exist between, as I said, must exist between those branches. But in order for the wheels of the democracy to keep turning smoothly, they must not cross paths. Now, there is one philosopher, I believe his name is Byron, a very, very known French philosopher, who talked about, and I came across this quote. I don't necessarily have the year in which it was taken, but I came across this quote that I find very helpful in our discussion. It says that there is no liberty of power of judging if judging is not separated from the legislative and the executive. I'll tell you what is the thinking behind that concept. The thinking behind that concept is that you must not be the judge in your own cause. That's simply, whenever we use that phrase, we're simply saying, listen, you must not be the victim and the judge at the same time. What the French philosopher is saying, why there must be a separation of powers. There should never be a situation in a country where the executive is both legislator and judicial officer. So we will have the legislator, who is one who is responsible for making and unmaking laws, making and unmaking laws. We will have the executive, which ought to make certain directions and policies for the running of a country. And we will have them sitting in the same chair as the person responsible for enforcing that law. There must never be such a situation. And therefore, I believe the philosopher's comment or his writings became very, very important when I was looking at this topic. There should be an end to everything. This is what he's basically saying. There should be an end to everything. If the same man, there will be an end to everything if the same man or the same body, whether it's nobles or persons, if they were to exercise those powers of enacting the law, executing public affairs, and then trying crimes of individual causes, it must never be the same person. So this brings us to understanding, to an understanding. Whenever we're talking about separations of power, we're talking about each branch understanding their function and rules, and that they are exercising that function and their roles separate from any influence or separate from any direction of the other branch. All right? And that is why it's important. The doctrine of separations of power in the Constitution are, of course, important because each organ or each branch is vested with a certain power that can only be undermined if the other branch or if an outside branch steps in and attempts to influence its operations. Now, this doctrine of when you go through the Constitution of the Cooperative Republic of Guyana, you would recognize that the doctrine of separations of power is both implied and expressed in the text of the Constitution. Now, a case that is very important, and we are going to begin to examine that case in a subsequent discussion, the case of Heinz and the Queen. All right? It's a very important case, and we will discuss that case. Now, what we will look at when we try to examine this doctrine, we will look at the same case of Heinz. We will look at the structure of the Constitution. We will look at the history and the tradition of the Constitution. We will look at the rule of law in a democratic society. And we will look at the protection of the law and what the law affords. That is due process. And then we will look at the protection of the independence of the judiciary. We will also look at Parliament and its control that it has over its own internal proceedings. Then we will also look at Parliament maintaining an effective control over its powers that it delegates. And then we're going to look at judicial review of legislation, which is sometimes permitted with limits. So these are some very important areas that you will find that we will discuss over a series of discussions following the separations of power. So today I want to thank you for listening, and I want to, in summary, remind you that there are three important pillars in a democratic society. There are three important pillars that we must consider whenever we're looking at the separations of power. In some instances, you may want to refer to these pillars as branches of the state. And those three branches of the state that we will consider would be the legislative, the executive, and the judicial branch. And you will see in subsequent news broadcasts or discussions how we are going to examine individually their roles and functions, and of course advocate that at no time there must be a crossing of these roles. And I thank you for listening until another broadcast. Audio Jungle.